Hey guys, my name is Shashwat and I am a legal intern at LEXIS and Company. Today, in this video, I will be talking about the case MC Mehta versus Union of India. This case was filed by MC Mehta, a social activist lawyer. He sought closure for Shriram Industries as it was engaged in manufacturing of hazardous substances and located in a densely populated area of Kirtinagar. While the petition was pending, on 4th and 6th December in 1985, there was leakage of oleum gas from one of its units, which caused the death of an advocate and affected health of several others. This incident took place on December 4th, 1995. Just after 1 year from the Bhopal gas disaster, a large number of persons, both amongst the unknown and all the workmen and public, were affected. This incident also reminded of the Bhopal Holocaust that had happened just before. So MC Mehta filed a PIL under Article 21 and 32 of the Constitution of India and sought closure and reallocation of the Shriram caustic chlorine and sulfuric acid plant, which was located in the thickly and a very densely populated area. Then factories were closed down immediately as inspector of the factories and the commissioner of the factory issued separate order dated December 8 and 24, 1985. The incident took place only few months before the Environmental Protection Act, which came into force. Thus, it became a guiding force for having an effective law like this. There are 6 report cases in the Shriram food and fertilizer industry in the Supreme Court of India. Out of these 6, 4 were pronounced before the Environmental Protection Act 1986, and the date from which it came into force. So that means I'm trying to say that out of the 6 reports, 4 were filed just before the Environmental Protection Act. So the reported orders were relevant and important as they shed new light on how highly toxic and hazardous substance the industry is dealing with, which can affect many people in that area. So the major issue was, firstly, whether such hazardous industries to be allowed to operate in such populated areas. Secondly, if they are allowed to work in such areas, whether any regulating mechanism must be evolved. And thirdly, liability and amount of the compensation, how to be determined if anything goes wrong. These were the issues that came in the case. So the Supreme Court took a look on this case and came up with few observations. Since they are not the deciding for the question, as to say Shriram is an authority within the meaning of Article 12, so as to be subjected to the discipline of the fundamental right under Article 21, we do not think it would be justified in setting up a special machinery for investigating of the claims for compensation made by those who allege that they have been victims of the oleum gas tragedy. So, but the Supreme Court would direct that Delhi Legal Aid and Advice Board must take up the case, and for all those who claim to have suffered on the account of the oleum gas, and to file actions on their behalf in the appropriate court for claiming compensation that they must get. Such actions claiming compensations may be filed in the Delhi Legal Aid and Advice Board within 2 months from that date in Delhi administration, as directed by Supreme Court. So, thus the High Court was directed to nominate one or more judges as may be necessary for the purpose of trying such action, so that there may be expenditure expeditiously disposed of, simply because the gas caused death and many people were hospitalized. So this was the case about the MC Mehta versus Union of India, which is a landmark case in the Indian Constitution. That's it for today. If you like this video, please like, share and subscribe, and stay tuned.